Be seated. Second case for this afternoon is a Federal Way School District versus Vinson. We'll hear first from Mr. Firkins, 15 minutes.
Thank you, Your Honor. My name is Tyler Firkins, and I represent a public school teacher, David Vinson. This is Mr. Vinson's appeal from a Court of Appeals decision that altered decisions made both by a hearing officer and the Superior Court, and in doing so created a radical new rule that overrules nearly a century of holdings in this case as it relates to sufficient cause and the nexus that is required between the conduct alleged and the teacher's job performance. So the Vinson Court turns away from the teacher discharge statutes in three different ways. The first one is by radically redefining the sufficient cause standard and by applying a loose and vague and therefore unconstitutional standard that could apply to almost any conduct. The second way the Vinson case turns away from the teacher discharge statutes is that it allows an appeal to the school district where no appeal is allowed under the statute that specifically applies. Third, even if an appeal is not allowed, as the statute clearly indicates, the Vinson Court allows the school district nevertheless to file an appeal. And in doing so, it basically sidesteps the gatekeeping function of the writ of review under RCW 7.16.040 and allows any school district to appeal an adverse hearing on a mere error of law standard to even get into the door to see whether on the merits of the case, whether the merits of the case should be addressed.
Do you think that there should ever be a right to file a writ of review from a hearing officer's decision, or that the school district should ever have a right to review under the 7.16.040?
I think in some circumstances, I think the concept is that the legislature specifically envisioned the teacher discharge scheme to not permit the school districts to appeal. But there are extraordinary circumstances that do exist, which is the purpose of RCW 7.16.040, which is that under extraordinary circumstances involving extraordinary situations that people can seek review. And indeed, the 040 standard that this court has created in WPEA and other cases, and most recently in Holofield, creates a gatekeeping function for the courts to see whether this is an extraordinary circumstance and whether it is something that allows them to even enter the court and basically defy the legislative scheme that is created.
Well, it's not quite defiance. The legislature didn't say no review. And I'm minded we've had a number of LUPA cases here in which the legislature expressly said in a Land Use Planning Act appeal, this replaces the petition for certiorari and is the exclusive remedy. There is no other remedy. The legislature didn't say that here.
No, they didn't. And what Kelso did is interesting, because what Kelso suggests is a form of statutory construction that can be found nowhere in the law, which is that Kelso suggests that when in 1975 through 77 there were a variety of amendments that were taking place, Kelso determined that they must have forgotten to change this statute, and as a consequence, we're going to go ahead and grant them the right that the legislature specifically did not provide. Clearly, there's no case that's ever been decided by this court that says we can simply assume that the legislature forgot to change a statute and instead impose a different rule than what is actually in the statute.
Counsel, I'm looking at the language of Section 040, 7.16.040, and one of the grounds for issuing the writ is to correct any erroneous or void proceeding. So when do you think that applies, to correct any erroneous or void proceeding?
Well, the way that the Federal Way School District is arguing 040, if the court simply says that that language or the common law language that comes below that allows any petitioner basically to enter the court to correct a mere error of law, then there was no point in this court deciding the City of Seattle versus Hollifield. In other words, 040 becomes swallowed entirely by that language that means essentially that there is no gatekeeping function because any error of law can be addressed by the courts. And clearly, it just creates a situation where the courts are saying, well, these words have no meaning.
Well, if we agree with you on that, I mean, what would be an example, or when would the court ever be able to correct any erroneous or void proceeding?
Well, I think we go back to the language that the court has used over and over again when we talk about a writ of certiorari, which is an extraordinary remedy. Over and over again, this court repeats in every case involving a writ of certiorari that it's an extraordinary circumstance. And correcting a mere error of law isn't an extraordinary circumstance. And clearly, in this case, there's no extraordinary circumstance and no significant departure from the law except for what the Court of Appeals did.
Well, the Court of Appeals looks at it as conceded that Vinson, quote, ultimately admitted to lying during the course of the investigation.
That's correct.
And that's the core of it. The Court of Appeals is basically saying if you lie in an investigation and a teacher.
That's right. And what they did is they created a law that doesn't exist. If we look at the actual statutory construction of 28A, 405, 300, and 310, the authority to determine what is sufficient cause is bestowed upon the hearing officer alone. The legislature didn't say, we will determine cause. They said sufficient cause. And if you read Webster's dictionary about what sufficient means, it means enough. Is there enough cause? Clearly, that implies some sort of weighing by the hearing officer to determine whether there is enough cause. And in this particular case, the court has previously in Hoagland created factors that allow the hearing officer to take into consideration the circumstances surrounding the particularized situation. As an example, in this case, the hearing officer found very specifically in his findings of fact that the school district's investigation of Mr. Vinson was biased and improper. That is a finding of fact that was not appealed. It's a verity before this court. Given that fact, the question then becomes is whether if we take those circumstances under consideration, whether there was sufficient cause, and the hearing officer weighed it and made that decision. The question then becomes whether a subsequent court can simply substitute its decision for what the hearing officer did and say, well, we weigh this differently and we say this instead.
I think you missed the thrust of my earlier question. I was looking at was admitted facts. The teacher admitted lying during the course of the investigation.
That's true.
The teacher admitted in public referring to a minor school girl as a effing bee and a whore.
She was not a minor schoolgirl. She wasn't a schoolgirl, and she was not a minor. She was a former student at Federal Way High School who had previously called in.
That makes it all right, then? She's a former student, so that's all right.
Well, is it ideal conduct? No, but if we go back to Brown versus Gear,
I'm just saying that he admitted that conduct, so apparently that is not sufficient for, I guess, any discipline, much less termination.
Well, the question, Your Honor, is whether you're going to create a standard that can be applied simply by any court, the last court that looks at it, as opposed to create a standard that both school districts and school teachers can look at and apply. The current test, as it's formulated by the Vinson Court, is it lacks any professional purpose. They've taken the Clark test, they've deconstructed it to be 3 or 4 words. And what do those words mean? They are meaningless. Lacks any professional purpose could apply to virtually any conduct, whether lawful or unlawful, of any particular teacher. So, and in the context of teacher revocation statute, we have moral turpitude issues and unprofessional conduct. And when we look at those particular situations, constitutionally it has to be more than just vague words that have no meaning. There has to be, courts have repeatedly found, a nexus between the alleged conduct and the performance of the teacher. And that's both with regard to the WAC regulations about unprofessional conduct It has to do with, in Gaylord, when we talked about the immorality of a teacher, and it had to do with a criminal conviction in the Hoagland case. For 100 years now, since Brown versus Geer, we have always said that there has to be a nexus between the alleged conduct and the teacher's performance. One of the verities on appeal here is that there is virtually no impact on Mr. Vinson's performance. That issue was not appealed. It was a finding of fact entered by the hearing officer.
Counsel, I wanted to ask you another question. You said that the hearing officer found that this was an unfair and I think you said biased investigation. I'm just wondering, I missed that. I'm just wondering where that is.
I have it marked, Your Honor. It's page 5 of the decision at paragraph 21, where the court says, or the hearing officer says, this perception in this regard were not unreasonable, and it also appears that the investigation of the May 1st, 2007 incident was not conducted in an unfair and impartial manner.
He's referring to Wood. He's not referring to the board that made the decision here. Or who is he referring to?
Okay.
Well, the investigation was performed by Mr. Wood, so that is what he was referring to. And that was what Mr. Vinson was responding to, was Mr. Wood, who was the one that performed the investigation. And that particular incident, the May 1st incident, was the one at the taco time involving the adult who formerly went to the school district.
I take from your answer that would make a difference if this were a student.
Absolutely. Absolutely. And I think one of the issues that we have here is that if we looked at the history of discharge as a matter of law, first of all, I don't think there is any authority under the statutes to allow a court to discharge somebody as a matter of law. That came out of Hoagland, which was a summary judgment case where the court ruled on CR 56 that they could be discharged as a matter of law under those particular facts where there was no reasonable trier of fact could have found anything else. And actually, this court reversed and said that you should have a hearing on those facts to connect the nexus. So, but since then, many courts have said as a matter of law, with regard to conduct that involves sexual abuse of children or hazard to children. And that's perfectly reasonable because there are statutes that deal with that sort of conduct, whether it's predatory grooming or whether it's actually physically abusing children. It's all illegal. And therefore, there's an inherent connection between that conduct and...
Well, Counsel, can I stop you there, though? Because this, as we're trying to kind of, you're asking us to sort of retrace our steps, that there's been a drift since Hoagland and through Clark. And so, yet you want us to not back off of this notion that in egregious cases it can be decided as a matter of law. Why wouldn't we simply say that in the context in which we're saying as a matter of law, it's just that reasonable minds couldn't differ, that on the facts, the sufficient cause would necessarily be shown. I guess I want to be clear, you're not, it sounds at times in your briefing and what you just said that you're asking us to endorse narrow instances, perhaps on a statutory basis or because it's sexual misconduct, where we change the rules.
Yeah, I'm actually not suggesting that. I'm actually suggesting that in every instance we should apply the Hoagland factors, which was what I think was envisioned in the first instance. But if you are going to depart from that and say that in certain instances it can be as a matter of law, that should be a very narrow exception, because if you don't create a very narrow exception under those circumstances, you will, as in this case, have an ever-expanding group of decisions where some court simply pulls from thin air the concept that this is another basis that where you can discharge somebody as a matter of law. Being the last court that confronted this issue, that's how we decided, despite the fact that two other courts decided differently. So my first suggestion to the court is to clarify that the Hoagland factors should be applied in every case, because in every case they inform the court about the circumstances surrounding the conduct and allow a hearing officer to take that into consideration. Here, the Vinson court decided that it was actually error of law for the hearing officer to apply the Hoagland factors. Nowhere in the case history does it suggest that it's a matter of, that as a matter of law, it's an error to apply the Hoagland factors. In fact, in Clark, it appears completely discretionary. And in Clark, they did apply the Hoagland factors with regard to work.
Counsel, let me interrupt you for just a second. One thing you have requested here is attorney fees, and if we were to rule in your favor, I'm just wondering on what basis you think we could give you attorney fees in this case?
Well, the answer is that if the school district does indeed have a right to appeal, which they appear to have been granted under a writ of review, if you go back to 310, it says that the prevailing party is entitled to, not the prevailing party, but the teacher, if they prevail, is entitled to attorney's fees. And so my answer is that RCW 28A 405-310, I think it's 9 or 10, says that the employee, if he prevails, A, gets reinstated, and B, gets attorney's fees. Because Mr. Vinson waived his right to fees at the hearing to moot the case, he should be entitled to attorney's fees on appeal because the school district unmooted the case, and here we stand where Mr. Vinson, like a lot of school teachers, has a very difficult time affording attorney's fees to go from a hearing officer to a superior court to a court of appeals to the Supreme Court. And in fact, one of the problems with creating a subjective rule that is in effect meaningless, that lacks any professional purpose, is that the school districts can use their financial power to overwhelm teachers and drag them through every court that is available, all the way to the Supreme Court. And that's no inexpensive task for teachers to afford that, and it's an unfair fight, frankly. And for that reason, it's another reason. So I'd like to reserve the balance of my time for rebuttal. Thank you.
Vinson, you have 20 minutes.
Thank you, and may it please the court. Jeff Ganson, accompanied by Rachel Miller for Federal Way School District. I'll start out with the writ of review. There's absolutely nothing obviously in 28A 405 that would preclude review of a hearing officer's decision by a writ.
Well, that statute doesn't give a school district a right to appeal.
Certainly.
Only the employee, the teacher, or the principal, or...
Certainly that's true, and I think you could even fairly say that we can't stand here today and say it was the legislature's intention to include a specific appeal provision.
Well, your argument, legislature didn't give us a right to appeal, but no problem, we'll just use the statutory writ of review to get our appeal right.
Well, I think that's
what the legislature intended?
I think we have to assume that is what the legislature intended. The legislature adopted what is now Chapter 716, well over 100 years ago, and subsequently has adopted and revised over the years Chapter 28A 405.
Judge Dwyer, in his dissent, pointed out that seemingly this court in 1957, which was a while back, but the case is still out there, said, and that and I'm talking about the Bates case, you probably picked up on that, which is a labor and industry case, and he quotes this from this court: since the legislature saw fit to withhold from the department, I guess we could say insert Federal Way or school districts, to withhold from the department any right to appeal from the decisions of the board, it follows that in the absence of some legislative expression indicating a contrary intention, the Superior Court had no jurisdiction to entertain and grant an application for certiorari, which would in effect permit the department to do precisely what the legislature said it may not do. Now, I guess you'd probably say, well, they didn't say we couldn't. They didn't say we could.
Well, that is the distinction, Your Honor. The Kelso decision is mischaracterized by counsel in the sense that the Kelso court did not say, oh, we think the legislature intended there to be a bilateral appeal provision, so we're going to create one. The Kelso court said there's nothing in 28A 405 that speaks of a school district's right to appeal. However, we have 716.040, which provides an independent basis if the school district can demonstrate that it meets the standard there. And how that's different from the Bates decision is that the statute at issue in Bates was the Industrial Insurance Act, which very explicitly abolished the jurisdiction of the courts over industrial insurance, workman's comp sorts of cases, with very limited and explicit exceptions. And so the Bates court reasonably said, in the context of the Industrial Insurance Act, the superior courts became courts of limited jurisdiction and could not apply 716.
Say, for sake of argument, you're correct on that. It can't just be a substitute for the right to appeal that you weren't granted in 28A. It has to. Wouldn't your argument to the court have to be more extraordinary than that?
Certainly, and we recognize this is an extraordinary writ and it's an extraordinary remedy. And counsel is correct in saying that 716-040 performs a gatekeeping function. It absolutely does. And as this court said a few months ago in the Holyfield case, in some circumstances, you're going to have to meet a pretty high standard to get in the door on a writ, to even be heard. And as we've argued, as you've seen in our supplemental brief, we think that decision is limited to the context of interlocutory review. But certainly, it's an extraordinary situation. But if you look at the development of the case law around teacher discharge cases, there have been dozens of reported decisions on these cases. And in the last 30 years, 2 and now just recently 3 that arise out of a writ. It is extraordinary.
Well, counsel, what is the difference between the scope of review under the writ and the scope of review under 28A?
Under the writ, I believe the case law says that there has to be a clear error of law. So when we're looking at errors of law, it's not de novo review, which the cases arising out of the 28A 405 right that employees have to appeal, they get something, there's a less deferential standard to the hearing officer's decision. Under a writ, errors of law have to be clear. To attack the findings of the hearing officer or the inferior tribunal, we have to show arbitrary and capricious findings.
I'm looking at Section 040, and I don't see any of the words you're using. I mean, I don't see anything about error of law. I don't see anything about arbitrary and capricious. I don't see anything about evidence supporting the findings or lack of evidence supporting the findings. How do you reconcile your position with the language of the statute, the language of 7.16.040?
716.040 deals with when the court is required to grant the writ, which is opening the doors of the courthouse to a party who's aggrieved by the inferior tribunal's decision. And that says, under these circumstances, the court shall issue a writ and allow review. And, of course, they all involve that there is no other appeal process available. So that right there contemplates that this is going to apply in circumstances where the other statutory law is silent on the question of this party's right to appeal. And then it says you can get there, you're entitled to a writ, if you can demonstrate that that tribunal lacked jurisdiction, that it acted illegally, which, as we've seen, this court has recently interpreted, or if the proceeding was erroneous or void, or if the proceeding was contrary to the course of the common law. And so our answer to Your Honor's question is we think we meet 2 of those standards. We think we meet the Holyfield standard because the hearing officer's decision in this case undeniably prevented the district from substantially and materially prevented the district from acting in a way that we believe the district otherwise could have and had a right to. But we think we also meet the erroneous proceeding standard as well, that the proceeding has been affected by an error of law.
Well, that doesn't really make a proceeding erroneous. I mean, erroneous seems to modify proceeding. There has to be something wrong with the process, it seems like. Do you think that leads you directly to the conclusion that any error of law is appealable under the writ?
Any error of law that that leaves a party with no other remedy. And I will freely admit that 040, as I think this court said in Holyfield, is not a model of clarity. And I think everyone in the room would wish it were clearer. But we have to work with what we have. And at this point, our position is an erroneous proceeding is one that's affected by a clear error of law, say. So not a minor error of law, but one that gets back to what you said in Holyfield. This decision has substantially altered a party's ability to act.
Well, what's the clear error of law?
The clear error of law in this case is the hearing officers having reviewed and had before him this court's law on sufficient cause, the Clark, Hogan, Mott, and all of the reasonable interpretations of those decisions and of the law that has developed in the courts of appeals, and said, well, ultimately, this guy has an explanation for what he did. And so even though this clearly meets the second prong of Clark, it's conduct that serves no positive professional purpose, no positive educational purpose. It's purely self-serving. And even though it happens on work time, at work and in direct relation to directives and pointed questioning from his superiors.
So you were referring just to the lying to the investigation, the other exchange that I talked about with your opposing counsel. We are focused here, as the Court of Appeals did, on lying to investigate.
That's how the issue has evolved. The district has never abandoned the argument that the hearing officer's decision was also an error of law in finding that conduct towards somebody, this sort of conduct by a school teacher towards somebody who had previously been involved in an investigation of his conduct and following clear directives not to retaliate against people who had participated in those prior investigations, that's misconduct. It's insubordination every bit as much, we think, as sitting in front of your boss and saying, I'm not going to do what you're telling me to do, which is tell the truth about this exchange you've had, which, by the way, was not just an exchange with a community member and former student. The allegation that the district set out to investigate was that that exchange occurred in front of students, that Vinson was accompanied by students. It's uncontested that there were children at the restaurant where this exchange occurred.
It was off premises. It was not at the school, but students were there.
Right,
But,
and that's
was not a student anymore.
That's correct.
Okay.
Was not a student of his, and I honestly don't recall whether she was still enrolled in the district. I don't think she was. But there's a nexus in the sense that she had participated in this investigation, and there's also a nexus in a very legitimate concern that this behavior was occurring in front of school children, that Vinson, his students.
And you think that's a clear error of law?
We do, because what it says is the result of the hearing officer's decision is, regardless of the fact that the school district has proven by a preponderance of the evidence that this person engaged in what everybody would agree was misconduct, the hearing officer says it's inappropriate.
Now you're shifting from that to the investigation?
I'm sorry.
Still on the taco time incident, or are you now shifting back to the...
You were asking error of law around the retaliation piece?
The taco time piece.
Yeah, we still say it's error of law because even though that was happening away from the school setting, he was violating a directive that had been given to him in his workplace. And so that's direct insubordination. And so we do believe that's an error of law. But we don't think you need to get there because the lying in the course of an investigation clearly happens at work, clearly happens in relation to a legitimate investigation of his conduct that has been alleged to have occurred with students. And so that's it's more clear that that's job related.
It sounds to me a little bit like you're saying whenever a hearing officer does not find, when a hearing officer finds that there is misconduct, but it's not sufficient to justify termination, that's an error of law. Sounds to me like that.
Well, I think we have to,
They're always going to be wrong if they find, well, the teacher spit in the sidewalk, that doesn't serve any educational function. It occurred during the work. That's misconduct to do that in the presence of students. But I don't think that's sufficient justification for termination. You'd say error of law. There's misconduct. He admitted it. Occurred at work. End of case.
No, that wouldn't be our position at all, Your Honor. The touchstone is still this court's decision in Barnes, which says sufficient cause exists when the teacher so breaches his contract, his promise to teach, that it excuses the school district of its obligation to continue to employ the teacher. And so the subsequent cases provide ways of getting at that question. And so you have Clark saying,
those kinds of determinations are fact specific. I mean, the circumstances which caused the teacher to do this, who was there. I mean, those are all. Argue endlessly about those from a factual standpoint.
And some of them undoubtedly are. And that's why Hoagland exists. Hoagland gives us 8 factors by which to judge the job relatedness, the nexus between a teacher's conduct or status against his ability to actually do the job, to continue to be a public school teacher. And in some cases, this court has said in Mott, in some cases, misconduct is so egregious that as a matter of law, it is job-related. It does constitute a breach. And this court can certainly clarify what was meant in Mott, but the lower courts have appropriately...
The lower court said, well, I know it when I see it. This is... hearing officer said this didn't justify termination, but I know it because I have this sense that it's so egregious that error of law. That's kind of your point?
Well, if there's ever any doubt in a hearing officer's or a court's mind about the job relatedness of the conduct, one way to approach that issue is to look at the Hoagland factors and go through them. Well, did this teacher spitting on the sidewalk, or to use the WA amicus example, a teacher lies about her whereabouts while honestly denying the conduct that she's been accused of or that she's being asked about. That's an immaterial lie. No trier of fact is going to find that has the lie about, she was at dinner and not out jogging. It has no bearing. There's clearly no nexus. So in some cases, the more extreme examples of spitting on the sidewalk, no one's going to argue that those things constitute a breach of the contract to teach. What we're saying is when you sit down in front of your boss and your boss says, you have unsupervised conduct with students. We rely on you to do what we tell you, and we rely on you to honestly report your interactions with students. Because...
By the way, on these hearings, is there anything else that the hearing officer can do, or is it all or nothing? In other words, could a hearing officer say, well, I think this is pretty bad. You lied or you did this or that, but I don't think it justifies termination, but you should be suspended for 10 days or something like that. Can they do that, or is it all or nothing?
The lower courts have said that the hearing officer's job is to find the facts, apply the sufficient cause standard, and determine whether there's sufficient cause to affect the employee in contract status, yes or no. And then and bear in mind that a teacher in this position, teacher in Vinson's position, during this hearing process has not been terminated. They're typically on leave, but they're not terminated. Their contract has not been terminated. And so once a hearing officer finds sufficient cause, yes, school district, you are entitled to affect this person's contract. That decision goes back to the school board to make a policy decision. What is the appropriate punishment? And there again, hearing officer Cooper in this case ignored that limitation on his authority when he explicitly said, I'm concerned that the punishment fit the crime here. He found a crime, but he didn't like the punishment that was proposed, and so his method of altering the result was to say, I also find that this guy lied, and that's bad, and there's no justification for it, but I believe he believes his explanation for why he lied. And let's be...
Time is running short, and I want to ask you about attorney's fees. You only addressed it in one of your, I think it's your opening brief in the Court of Appeals, and you say there, if the final decision is in favor of the employee shall be awarded attorney's fees, and you quote Section 310. And then your argument is that because Vinson should not prevail, therefore he shouldn't get fees. Would it be your position that in the event Vinson does prevail, ultimately, if the hearing officer's word were upheld, that he would be entitled to his attorney's fees?
In the context of a writ, I don't believe so, because we are at that point in court.
Wasn't this in the context of a writ?
Yes, it is.
This is your brief in the Court of Appeals, and you're citing 310 as a basis for fees.
Right. Well, I believe Vinson was citing 310 as a basis for fees. We were explaining why we thought that didn't apply.
But you're saying it doesn't apply because we should conclude that the district did possess sufficient cause to dismiss Vinson.
Right. So there's no authority in Chapter 716 for attorney's fees in cases dealing with extraordinary writs. If that's something that the legislature thinks should be fixed, they can fix it.
If an employee prevails at the hearing officer level, can the employee bring an appeal under 28A in order to secure a right to attorney's fees in the event the district wants to bring a writ?
I'm not sure I follow that. If the employee appeals before the hearing officer, the employee is absolutely entitled to attorney's fees for that hearing.
I'm saying to avoid the conundrum that if the employee prevails, he's not entitled to attorney's fees in the event the district seeks a review. But if the employee loses and then successfully appeals, he is entitled to fees. Does the employee have it in the employee's power to go ahead and appeal just to preserve that right and avoid what Judge Dwyer complained about in his dissent?
I honestly don't know. It's not an issue I've looked at. I wouldn't think it would be necessary because we don't contest that an employee has a right to attorney's fees coming out of the hearing or out of their own appeal to Superior Court. The only other sort of appeal I think they could bring would be try to do what we've done and come up through 716, but I don't think they could demonstrate that any of the standards in 040.
I'm not suggesting that. I guess I want to make sure that your answer, in part to the question under 28A, is that in the event that procedure applies, it would pick up appellate fees under 310.
That's right. So in the scenario where the employee loses in front of the hearing officer and wins in Superior Court, successfully appeals the hearing officer's decision, yes, I believe they're entitled to fees in that situation. I just simply would note that the issue, that isn't what happened here. Mr. Vinson waived his entitlement to fees, didn't raise this issue in front of the Court of Appeals, didn't, as far as I know, raise it in the petition to this court. So on that basis alone, I think that issue shouldn't be considered. But our point remains that that's really an issue. If we're here under 716, that's an issue for the legislature to address. Thank you.
You have 4 minutes.
Thank you, Your Honor. I want to point out a few factual issues that the district is arguing that are inaccurate. They are accepting as true the fact that there were students at the taco time. That information came directly from the accuser in the case, who was absolutely disbelieved by the hearing officer, who found her not to be credible. And therefore, those facts aren't before you. That is not an accurate statement of the facts.
Counsel, I'm more interested actually in the writ and wonder whether you have any definition that you would offer for an erroneous proceeding. What would a person trying to use the writ in the circumstances of a case like this have to show in order to use erroneous proceeding as the basis for bringing their writ?
Well, as an example, if a school district was not entitled to, or an employee was not entitled under a statute to file and obtain review of a particular case or appointment of hearing officer, let's say if they're laid off because of a RIF or financial reasons. It limits the circumstances that they could. And if they got a hearing officer and the court went ahead and appointed one as an example, then I think they could apply for a writ and say that's an erroneous proceeding. Under the statute, you're not allowed to access the court with respect to that particular statute. So that, as Justice Wiggins suggested, is an erroneous proceeding. It's not just a mere error of law. And again, I want to point out that what the district is suggesting is that if it's an interlocutory appeal, yeah, all your decisions that you've decided previously apply. But if it's an appeal that we don't have as a matter of right, but we're at the end of the case, then all those decisions don't apply, and we can just come in and say it's an error of law, which is, by the way, all the Vinson court said. It was an error of law. They didn't say it was a clear error of law. They said it was an error of law. And the distinction between a clear error of law and an actual error of law, I think, becomes a distinction without a difference. I think there has to be a higher standard, and the court should impose a higher standard because this is an extraordinary circumstance. It shouldn't be one where, hey, look, we got to appeal as a matter of right under this statute.
Do you agree, though, that even a clear error of law is a basis for bringing a writ?
No, I do not.
So if we agreed with you that this proceeding did not constitute an erroneous proceeding, then would we get to the question of sufficient cause and the standard?
You never would, because the Superior Court was right in denying the writ, and they never had a right to appeal in the first place. And as a consequence, we don't need to do that. I would urge the court, however, to clarify the sufficient cause standard, because I think it is creating quite a bit of problems out there for lawyers such as myself and Mr. Ganson in terms of trying to resolve cases, trying to anticipate what's going to happen, because we don't know if a court's just going to make up a new law and say, yeah, you can discharge this teacher as a matter of law in this particular instance because it lacks any professional purpose. I think the court has to take back its holding and really acknowledge that the sufficient cause standard, and the word sufficient means something more than nothing. It means that there should be a weighing of the circumstances surrounding the conduct rather than simply define whether the conduct actually took place. And whether the court says that in every instance it should apply the Hoagland factors, or whether it should say only in cases involving abuse of children do we apply the second standard, I don't think is particularly of any great importance. But I would point out that if any teacher comes into court and says that, yeah, well, I was grooming that child to sexually abuse them, and under the Hoagland factors, I win, we have seen throughout the history of these cases that that's simply not the case. Under every circumstance, Price, Potter, Mott, all those cases, even had the court applied, and in those cases did apply the Hoagland factors, the teacher lost, as they properly should. And so we should entrust, as the legislature did, the hearing officer with the decision as to whether the probable cause decided by the school district is sufficient for the conduct involved. And that is the important distinction in this particular case. So school districts are not entrusted.
Counsel, you need to wrap up your.
Okay. Your Honor, we would ask that the court address the issue of sufficient cause and the school district's right to appeal. Thank you.
Thank you. Court is in recess.
Supreme Court is